that I find my first debate as a Minister is about a bill that I find repugnant and regressive. I should have preferred to be talking about how Scotland is striving to live up to our global responsibilities as a place of welcome and sanctuary. Instead, I'm talking about the UK Government's Nationality and Borders Bill, which the UNHCR have said is fundamentally at odds with the UK's international obligations under the Refugee Convention. The bill sets out significant changes to UK asylum and immigration law, but it misdiagnoses the problems with the UK immigration and asylum policy. It will not achieve the aims that Home Secretary claims because it does not address the problem of incompetent management and ideologically misdirected policy by the Home Office and the UK Government. The bill will negatively impact people, communities and the provision of services. This Government condemns the bill and the UK Government's inhumane, hostile environment. The Scottish Government developed our pioneering New Scots approach in a partnership with COSLA and the Scottish Refugee Council. Our public services, third sector and communities work together to support our vision for a welcoming Scotland where refugees and asylum seeker integration is supported from day one. We are ambitious about embedding human rights and trauma-informed practice to improve how we support vulnerable people, including victims of human trafficking, domestic abuse survivors and children. We recognise that we need an inward flow of people to support our economy and the growth of our businesses, to develop services and to support strong, diverse communities. We have long advocated for a flexible, humane approach to migration based on the principles of dignity and respect. All of this is in jeopardy as a result of this UK Government bill. The bill is a long and complex piece of legislation introduced last July and roundly criticised since. The pace at which this sweeping and regressive piece of legislation has been pursued is purportedly due to an urgent need to give the Home Secretary more powers to fix the UK's broken asylum system. But let me be clear. The provisions in this bill will not fix the problems with the UK asylum and immigration systems. Instead, they will create barriers which will damage our communities, pushing already vulnerable people to the margins of society. They will add unnecessary complexity to the already challenging asylum system, restricting rights for refugees, based not on their need for protection, but how they arrived in the UK. Vulnerable people seeking protection will be criminalised, and pushback provisions will increase risk to life at sea. The door will be opened to offshore the accommodation of people seeking asylum, and there will be an increased risk of destitution, as no recourse to public funds restrictions will apply to more people. And just a second, and the Home Secretary will also have the power to revoke British citizenship from people without notice, which is quite astonishing.
Alex Cole-Hamilton.
I'm very grateful to the Minister for giving way, and I welcome him to his place. Does he agree with me that age assessment for the purposes of child protection is a devolved matter and that properly sits with social workers in an ethical framework here in Scotland, and with the Home Office in an immigration context? Does he also accept that quasi-scientific assessments to determine the age of children or a young person can be invasive and risk causing further trauma, and if incorrect can have the devastating consequence of having that young person return to the place from which they came?
Minister.
I thank Alex Cole-Hamilton for that intervention, as it preempts some of what I'm going to say, almost word for word, actually, and I fully agree with his intervention, and I look forward to him supporting this motion tonight. The bill provisions will increase the time people spend in limbo, waiting for a decision from the Home Office and unable to fully rebuild their lives. We already know that this puts pressure on people. It is detrimental to mental health, prevents people seeking asylum using their skills in the workplace and restricts access to financial support unless people are destitute. And this in turn shifts costs to our local authorities, public services, the third sector and communities. And the provisions in this bill will punish people who need protection and do nothing to tackle the underlying inhumane issues with the asylum and immigration system the UK Government has created. And if all that weren't bad enough, as organisations such as the Joint Council for the Welfare of Immigrants and the British Red Cross have pointed out, possibly worst of all, the bill risks creating the perfect conditions for criminals to exploit vulnerable adults and children. It doesn't just misdiagnose the problem, Presiding Officer, it is making the symptoms worse. The Scottish Government's questions to the Home Office about key issues in the consideration of legislative consent were met with delays and a refusal to accept the need to grant legislative consent. However, Scottish ministers are clear that this bill will impact heavily on Scotland's devolved competencies in a myriad of ways. Therefore, on the 1st of February, the Scottish Government lodged a legislative consent memorandum in the Social Justice Secretary's name, setting out 2 specific clauses which trigger the requirement for legislative consent. The UK Government have form when it comes to ignoring the wishes of this Parliament, and I fear they will not pay heed to the memorandum, just as they have ignored our concerns, the concerns of the Welsh Synod and the concerns of many charities and support organisations. But it is important that the Scottish Government is clear on our position and that we raise our opposition to provisions which will impact on devolved areas, as well as our overall opposition to the damage that will be caused by this bill. So, Presiding Officer, let me turn now to the 2 clauses raised in the memorandum. And to be clear, the assertion in the Conservative amendment that the provisions do not fall with legislative competence of this Parliament is entirely false. Clause 49 legislates in the devolved area of provision of care and support under children's legislation. The bill creates a national age assessment board, empowered and resourced to scrutinise age assessment determinations. This includes those made by social workers in Scotland for devolved purposes. If local authorities refer an age assessment to the board, the outcome of the board's assessment will be binding on them for devolved functions. This reach into devolved services clearly goes way beyond reserved matters of asylum and immigration. The bill also enables the board to use scientific techniques as part of age assessment. This is something that the Scottish Government guidance has consistently advised against on child welfare and unreliability grounds. And this is a position shared by medical experts, such as the Royal College of Paediatrics and Child Health and the Royal College of Nursing. It is a position that the United Nations Human Rights Committee describe as invasive, potentially harmful, and likely to result in children being wrongly assessed as adults. Concerns echoed by the Children's Commissioners for Scotland, Wales and Northern Ireland. These proposals are a retrograde step which will not protect the welfare of these highly vulnerable children and, in fact, could cause harm. The second clause in the LCM, Clause 58, would constrain Scottish ministers in terms of how any future Scottish competent authority could make decisions about who is a victim of human trafficking. And it will require late provision of information to support of a modern slavery or trafficking claim to be considered as damaging to a person's credibility. So what I reflect on when I consider the Nationality and Borders Bill is its basic lack of humanity, how regressive it is. The UK was a founding signatory of the 1951 UN Convention. It played a key role in developing the principles of the Convention and, as recently as 2018, reaffirmed these principles in the Global Compact on Refugees. And yet these obligations are meaningless under this bill. Not just my views, but the views of the UNHCR and the opinion of legal experts who have considered the bill on behalf of the Scottish Refugee Council. This is deeply worrying, particularly as the bill sets out an interpretation of the 1951 Convention that effectively seeks to establish the current government's definitions as the basis for consideration by UK courts. So, in conclusion, Presiding Officer, there is one area where I agree with the Home Secretary. The UK's asylum and immigration system is broken, but the Nationality and Borders Bill will not fix it. This bill could have been an opportunity for the UK Government to create a humane, fair immigration and asylum system. That opportunity has been missed. This bill will jeopardise the rights of thousands of people long into the future and have a profound impact on our society. It is anti-refugee, anti-human rights and anti-democratic. So I urge this Parliament to make clear its opposition to this bill, and I move the motion in my name.
The next question is that motion 3270 in the name of Neil Gray on Nationality and Borders Bill UK legislation be agreed. Are we all agreed? Yes. The Parliament is not agreed, therefore we will move to a vote and members should cast their votes now. The result of the vote on motion 3270 in the name of Neil Gray is yes 94, no 29. There were no abstentions. The motion is therefore agreed. That concludes decision time.